Hello and welcome to another episode of CISO Tradecraft, the podcast that provides you with the information, knowledge, and wisdom to be a more effective cybersecurity leader. My name is G. Mark Hardy. I'm your host for today, and we're going to have a little bit of fun by getting into some legal stuff. Specifically, we're going to go over a range of topics relative to CISOs, such as regulatory compliance, managing third-party risk, responding to data breaches, and the impact of things like GDPR and CCPA and MOUSC and all the other legislation and regulations that are coming out. We want to provide some practical advice and some real-world examples. So our special guest today is Mr. Thomas Ritter, a renowned lawyer specializing in cybersecurity. And Thomas has worked with numerous organizations to help them navigate the complex legal landscape of cybersecurity. Thomas, welcome to the show.
Thanks, G. Mark. Excited to be here. Looking forward to our discussion today.
I am too. I mean, another buddy of mine, Mark Rash, who was an attorney who was on our show a while ago. And Mark and I have spoken at the same event for years. And we're the type of guys that we get going. I think his record on a slide was never getting past slide 2. I mean, he just went off in his own little direction. So we're going to see how this one goes. But anyway, tell us a little bit about your background. How did you end up getting into cybersecurity law, which seems like a pretty specialized function? And again, it's a pretty neat opportunity.
Yeah, absolutely. So my journey in cybersecurity really started back in law school. I was in my third and last year of law school, and I actually took an elective that was titled something like Big Data in the Law. It was taught by a renowned antitrust attorney who had written extensively about big data and its implications, and continues to do so today. And I like to also laugh over the fact that I was one of 3 people in that class. I've always been someone that kind of marches to the beat of my own drum. And I remember thinking at the time, this course may end up being either a complete waste of time or I might be onto something. So I was really fascinated by a lot of what we discussed. And coming out of my law school experience, I actually started as a regulatory attorney, which segued rather nicely into me then going and working as a full-time privacy and security attorney for a couple different big law firms. And then fast forward to this year, and I actually left a big firm and started my own boutique law firm with one other individual here in Nashville, Tennessee. And we are just solely dedicated to assisting clients with their cybersecurity and privacy needs. And as part of that, we're often working alongside CISOs and trying to find ways to help them with any of the challenges they confront on a day-to-day basis.
Well, that's great. And welcome to the world of entrepreneurship. It's a lot of fun, a little bit scary, but it's something that I have done over the years. And I found that at the end of the day, it's as much there as you're willing to work for. And you got to keep banging at it. So I think you're into a hot area, and I think it's wonderful, and hopefully be able to provide some really good advice for folks. But so as we look at cybersecurity, in general, it's a hot topic. It's worked its way up to the board level over the next couple of years. We as CISOs and security practitioners, well, we've been doing it a long time, so we're kind of used to it. But from your perspective, what are some of the biggest legal challenges that CISOs are facing today?
Sure. Yeah, I think for starters, it's just constantly keeping up with the ever-evolving regulatory landscape. If you think about just in the last 12 to 24 months, you've had, amendments to things like New York Department of Financial Services cybersecurity regulations take place. You've had the SEC amend their cybersecurity regulations. State breach notification laws are always being amended. And so in all honesty and candor, a big part of my job is spending, at a minimum, probably an hour a day just keeping up with all of this, right? And so huge lift and ask to have CISOs try to adhere to that responsibility. And at the risk of sounding self-serving, that's where lawyers come into play, right? And so I think that's a big one. Another one for me is really just managing third-party risks. I'm hearing that from CISOs a lot, especially with the increase in outsourcing and cloud services that are part of day-to-day business ops. And, a microcosm of of third-party risk is really this year, right? If you look at some of the largest security incidents thus far in 2024, they've emanated from third-party providers like Change Healthcare, ConnectWise, Snowflake. We could go on and on. So ensuring that third-party vendors adhere to the same cybersecurity standards can really be complex and honestly should involve assistance from legal counsel.
Yeah, that third-party risk is particularly troublesome because a lot of times you find out that it's outside of your control. As a CISO, you don't control your third parties. And so as a result, we often depend upon policies for doing that. And I'm working with one of my clients where they have a large manufacturer who's kind of dinged us in terms of going through their security assessment of the organization saying, well, you don't have a third-party risk policy that goes down to the fourth party and the fifth and the nth party. And I'm thinking, well, as a consulting firm, you can't be very big unless you get ridiculous. Okay, well, I got Microsoft and I'm like on a Dell computer. Well, then who manufactures the board for Dell? That's kind of out of scope. Who is writing code for Microsoft that's a little out of scope. But I can see if you're a manufacturer, you're making, let's say, an aircraft, and then you have to have engine assemblies of which you're going to have other component assemblies of which you're going to have parts, and that could be 4, 5, 6, 7, 8, and N like that. So depending upon what industry you're in may determine the depth of that third-party concern. But how would one effectively assess the correct depth as a CISO? Is that a call that the CISO should be making? Is that something that the legal would make? Manufacturing? Who gets to say, yeah, here's how deep third-party is?
Yeah, it's a great question. I think, in my opinion, it should be legal in tandem with CISOs, right? And, from a foundational perspective, even just knowing, numerous degrees of depth is a great starting point. I think the first and second and third degrees should, at a bare minimum, probably be the baseline standard when you're thinking about, what's reasonable, right? With respect to legal liability. But, I also think whether you admit to or not, you raise a great point too, that when you're thinking about due diligence with third-party risk, and, assessing third-party vendors' cybersecurity practices and, if they've had a history of security incidents, it's often a difficult thing to do because, right, you as a customer and a client of that vendor may not be in a position to negotiate or really have much leverage in looking into those sorts of things. So it's very much a push and pull. It can be tenuous at times, but from an overarching perspective, I think just even demonstrating that you have a TPRM program, you have, policies and procedures within that program, and that you have a vendor management program is a great starting point and really trying to reduce the risk of future and subsequent legal liability.
Well, that's a good point. And for those who haven't, TPRM, the third-party risk management, I always like to define acronyms as we go by. Most of us know that, but I'm just adding that for a show. But also you talk about vendor management program. And a vendor management program typically is not managed by the CISO. It's managed by whomever is dealing with the vendors. So that suggests that somebody either needs to be in a lead and a support role, and somebody else has to go ahead and decide, how does that work out? One of the dangers I think takes place is that a lot of times we're asked from a third party, hey, assess your security. How are you? Oh, yeah, we're good. Check, 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 check. Check all the boxes and then done. And that self-assessment is kind of what got things like the defense industrial base in trouble and why we're doing CMMC, because a lot of companies were self-attesting that they did stuff. Did I run my 10 miles today? Anybody double checking? Nope. Then yes, I did. And from that perspective, we find out that breaches were occurring and things are going sideways and then it goes wrong. So if you want to go ahead and prove that your vendor management program does have enough due diligence to ensure that it's defensible, again, is the other kind of the saying goes, anybody can be sued over anything, whether it'll be successful or not is another item. But in general, barring nuisance suits and things such as that, we're really concerned about where someone is actually at risk from being vulnerable to a suit. And so what would you recommend for a vendor management program with respect to due diligence to be able to point to it and say, yeah, well, they kind of really were doing their job and this was out of scope?
Yeah, it's a great question. I think in my experience of working alongside large organizations that have strong vendor management programs that exercise due diligence, there's a real simpatico between the folks in the procurement office, maybe general counsel and or external counsel, and then the security professionals, right? And security personnel's, CISO being maybe at the top of that list. And, really wanting to contractually shore some things up, having everyone be on the same page with respect to the kind of security representations that maybe we as a client are expecting this vendor to make, or even vice versa, right? And, I oftentimes commonly see clients have a misunderstanding over things like, when they're supposed to be notified of a vendor having a security incident, what the definition even is of a security incident or maybe a breach, as I think we're going to plan on maybe discussing a little bit later, and the implications of defining something as a breach, and so on and so forth. So I think that's kind of my long-winded way of saying, it's great if you can do things like conduct periodic reviews and assessments of a vendor, or even ask a vendor to engage in something like an external audit. But as already mentioned, that may not be possible, right? When you're working with or at the behest of like a Microsoft of the world. So I think, at a minimum, having an understanding of what's in the contract and trying to have everyone be on the same page about contractual expectations should be at foremost a priority.
You raise a good point, because a lot of times people think, oh, we got legal requirements. Well, there's more than just the law. There's also, of course, statutory and regulatory, and then there's contractual agreements. And then there's also things in the industry. For example, PCI, the Payment Card Industry Data Security Standard. It's not a legal requirement. It's not a law. Rather, it is a business requirement that is set up for organizations that are going to process credit cards, that they say, hey, we'll agree that I will meet these principles and be able to be validated at that in exchange for the ability to process credit cards. So if we look, though, at the legal and statutory obligations that are out there, as you had said at the beginning of the show, there is a number of them, potentially a patchwork at the state level, international level as well. But in general, what should CISOs be thinking about when they think about legal or statutory obligations?
Wow. Yeah, that's a big question. As you noted, the United States, I think, is a good starting point in that, unfortunately, I think to the detriment of businesses and organizational leaders, there's really no uniform framework, right? So you astutely pointed out, it is very much a patchwork system, and it follows, what's commonly referred to as the sectorial approach, right? And so you are obligated to follow industry-specific laws like HIPAA for healthcare entities, or Gramm-Leach-Bliley for financial institutions, and then you have the state-specific ones too. Using the example of a statutory obligation or requirement that is oftentimes missed by businesses is one actually that's based out of Massachusetts, and that's their data security regulation. I think it's pretty unique. It requires that any organization that possesses information on Massachusetts residents must adopt a comprehensive written information security program, or WISP. NYDFS cybersecurity regulation for entities that conduct or do business in New York also feature, well enumerated security requirements. And then, as you pointed out, oftentimes, business leaders and CISOs are kind of left in the wind, so to speak, on, what are best practices. Right now, an ongoing debate in lieu of, change and ascension and some of the large healthcare breaches is the omittance of the fact that there are no baseline security standards for HIPAA. And so there's a lot of talk in Washington and under the Biden administration of establishing baseline security standards. The American Hospital Association is pushing back on that. But it leaves people like CISOs in a tough spot if, you're having to decide, and oftentimes organizational leadership at the C-suite level is expecting you to decide, what the right standard is, or, that you have implemented security controls that would, quote unquote, constitute reasonable security measures.
But you brought up something I kind of want to go and probe at this real quickly. So Supreme Court, Chevron, recently, and saying, hey, after about 40 years of letting agencies essentially fill in the blanks for what we interpret a relatively vague or incomplete law, that appears to be a little bit at risk now in terms of the Supreme Court saying, no, you don't get to do that. Now, there's two sides of that I see it, and I'm looking for an expert opinion. One side of it says, hey, agencies can't just invent new ideas that are say, well, hey, nobody said we can't, so we're going to make you do that. And then the other side is a little bit of saying, hey, let's go ahead and try to make Congress do its job and be a little bit more specific. And in the absence of that, they're going to probably get a lot of feedback saying, hey, we ought to be doing something about it. Now, somewhere in between those extremes, there's probably a reasonable medium. So what's your read on this recent ruling from the Supreme Court with regard to Chevron, if you had a chance to look at it? And what's the implication then in cybersecurity?
Yeah, I have had a chance to look at it, and I've had quite a few conversations amongst, peers within the legal industry, and it seems as if unanimously everyone is rather shocked by it, right? That the Supreme Court has reversed a doctrine that's been in place for over 40 years. As far as where that leaves things, more questions than answers. When you think about the implications of cybersecurity regulations, it's wide ranging. I've already mentioned that the SEC has recently amended their cybersecurity regs. You have the Federal Trade Commission that's kind of seen as the de facto agency for privacy and security that has, regulations that typically are viewed through the lenses of, industry standards and best practices. And with, the Lopez Enterprise Bright v. Raimondo case or Lopez case that was decided at the end of June, all of that has been called into question on future authority for regulatory agencies like the ones I mentioned, SEC, FTC, and so on and so forth, to really promulgate rules and then, more importantly, enforce those rules. And so I've told clients by no means should it be viewed as, we suddenly should ignore these rules. I think if anything, it'll probably be a slow and steady drip, and that you'll see, someone like Tim Brown, right? The SolarWinds CISO, who's currently being sued by the SEC. I would venture to say that his attorneys, if they haven't already, are writing, a pleading that is saying, hey, whoa, SEC, you need to pump the brakes. But I think for CISOs, for organizations, this isn't a reason to just suddenly put your head in the sand and not follow agency rulemaking. I think you absolutely should. It's just, it'll be interesting to note that in the coming years, I would expect quite a few organizations that are the subject of enforcement actions to push back against what it is those agencies are trying to make them do. And the basis of that pushback is going to be, the dismissal of the Chevron doctrine.
So it's not to get out of jail free. So CISOs can't look at that because obviously it's not the point. But it does suggest, though, that maybe refocusing on things. But one of the important things I think CISOs should be aware of and should focus on is the concept of liability. And so what is the legal definition of liability without getting too far into detail? Maybe Law School 101 would be good enough for this. And then what's the basis for that, and how is that influencing companies, and what should we really be thinking about from that perspective?
Yeah, so there's a couple different ways to answer that. I mean, I think most simply, lawsuits derive more often than not from just statutory violations where a person who's been harmed brings suit over maybe a company failing to enact adequate security measures that resulted in a data breach. Um, Strictly speaking, that's often predicated upon a negligence claim. There are also state breach notification laws that provide what's called a private right of action to sue an organization. There's then a litany of laws that we've already mentioned that allow regulators to initiate enforcement actions against companies. One of the best and most common examples pointed to would be the Office of Civil Rights under the Department of Health and Human Services and how they routinely use HIPAA to bring enforcement actions against healthcare entities. And state attorney generals also do the same thing. As far as like liability as a whole, and speaking to negligence, a thing I think is really interesting that isn't really talked about that much is lawsuits that have been brought in recent years in Delaware over what's called caremark claims.
Yep.
So, as everyone well knows, the majority of companies choose to incorporate in Delaware because of, the tax implications of that and simplified corporate laws. But in recent years, plaintiffs' attorneys, and always leave it to plaintiffs' attorneys to find creative ways to try to sue someone, have tried to go after companies' board of directors using caremark claims. So the caremark standard has been around in Delaware for, I want to say 20 or 30 years, but it refers to conditions for director oversight liability under Delaware law. And in the context of data breach litigation, caremark claims have been used to support the notion that a company's board of director failed to prevent a data breach from happening and therefore brought corporate harm on the business. This was brought up after, as many listeners and CISOs probably remember, the Marriott breach. It also came up again with SolarWinds. And while these lawsuits were ultimately unsuccessful, I think the biggest takeaway from these cases, and something that CISOs and, general counsel and external counsel should be thinking about that operate within the space, is I would expect it to become a bigger and bigger deal, especially now that you have recent, amendments to the SEC regs. And I think plaintiffs' attorneys are going to just grow more sophisticated and nuanced in bringing caremark claims, but doing it under the auspice and aided and supported by, some of these newer amendments.
Now, this is the Delaware Chancery Court, or is this some other?
It is. Yes, it's been Delaware Chancery Courts.
Got it. So there's risk out here, not only for perhaps liability with regard to negligence, as you had mentioned. Now, the caremark idea, at least for boards anyway, as CISOs, most CISOs aren't sitting on the board. They might report to a board or certainly should be briefing them on a regular basis. But any safe harbors or protective actions that or companies can do to help mitigate their risk other than never make a mistake and do life perfectly?
Yeah, so it's actually a really timely question because right now, a number of states are either in the process or have outright passed some safe harbor data breach statutes, right? And I think this coincides with, and I need to probably back up and first explain that there's been just this exponential, explosion in data breach class action lawsuits in the last few years. It's been felt on the insurance side. It's definitely being felt on the corporate side, where nowadays, if you have a breach that requires you to report to regulators and individuals, depending upon how big the breach is and how many people you're reporting to, it's probably pretty safe to say that you're going to become a defendant in a class action lawsuit. So one state that actually just passed something a few months ago that my firm talked quite a bit about and have continued to have conversations with clients about is Tennessee, where I'm located. And Tennessee actually passed a data breach class action safe harbor some speculated maybe in response to change in Ascension because of, the large healthcare presence that is in the state of Tennessee. But essentially what this statute says is, if plaintiff class action attorneys are going to bring a data breach class action and do so successfully, they're actually now tasked with demonstrating gross negligence. So they've significantly hired the evidentiary standard that plaintiff class action attorneys need to use, which in turn should make it more difficult for these attorneys to bring these suits successfully. Ohio is another one that I think was the first state, if I'm not mistaken, back in 2017 or 2018 that actually passed something similar, which was actually, it's an affirmative defense. So, if a company is sued over a data breach, they can actually assert as an affirmative defense and point to this particular statute, and be provided some, protection, all predicated upon if they can demonstrate compliance with some of the security frameworks and standards like, NIST, ISO, and so on and so forth. So there are laws out there similar to what we were saying about, the overturn of the Chevron doctrine. I've really cautioned clients and CISOs against relying on this too heavily, particularly ones within the state of Tennessee. I mean, it does not provide blanket immunity, but I think it's absolutely something that's worth knowing about. And I think it should be something they can kind of use and maybe allow them to sleep a bit easier tonight if they're doing, some of the things on the back end, like trying to comply with different frameworks and having that appropriate due diligence in place when it comes to security in general.
Got it. See, compliance is important. I agree. There's a lot of different frameworks out there. In the absence of one specific one, we find out that a lot of organizations choose the one. For example, if you're doing a lot of business in the EU or in the APAC region, often use an ISO standard because ISO is the international standard, kind of like the metric system. Everybody but America uses it. And so as compared to over like here, we're using NIST or something else like that. But in addition to complying with the standard, it's important that we comply also with reporting requirements. And those reporting requirements, although they may not be tied to a particular standard, are nonetheless there and get you in trouble if you don't follow those rules. So what are the types of reporting requirements in cyber that CISO should be aware of and make sure that take place?
Yeah, it's another great question, and it's one that doesn't have an easy answer more often than not, because as I've already mentioned, reporting requirements are often largely dependent upon what industry an organization finds itself in. So complexity can come into play very, very quickly. So let's just kind of, for purposes of having fun, engage in a hypothetical. And that's, you have a publicly traded financial institution who undergoes an incident.
Mm-hmm.
Where does that leave that organization? Well, they could be subject to a litany of laws and regulations. They are subject to the SEC's cybersecurity regulations. They could be subject to NYDFS cybersecurity regulations. They're likely subject to Gramm-Leach-Bliley. They then have to worry about state breach notification laws and those coming into play if they had impacted individuals, within states that would implicate that state's breach notification law. So it's a patchwork and maze, as we both have said, of reporting requirements that make compliance really, really difficult. But, I think just from an overarching perspective and speaking about reporting requirements and timeframes, I first want to break it down by state. States for the most part are pretty lenient when it comes to when organizations who have made the legal determination that they have had a breach and then have obligations to notify individuals and regulatory authorities about that breach can do so within, a longer time frame. So one of the bare minimums, 30 days. You have some that go to 45 days. You have some states that are 60 days. And then you have some that leave it into a more ambiguous standard of of using the as soon as possible and without unreasonable delay language.
That's compared to SEC, which kind of puts the fire to your feet. And
yeah. So
I don't know anybody can complete an entire investigation, be authoritative. It's in 96 hours or something like that. You just don't know.
Completely agree. And yeah, you took the words out of my mouth. You compare the states to some of the, industry and regulatory frameworks like NYDFS and the SEC, who both feature 72-hour notification timelines based upon, right, like materiality. And it's just so difficult to do. And as someone that's been a part of, hundreds of security incidents, I can tell you that there are very, very few, maybe, probably I can count on one hand times in which within the first 3 days of the company and my client discovering that incident, they were at a point where they could capably make and at our advice have made a determination that it rises to the level of a reportable incident or a breach.
Mm-hmm.
So I think you make a great point. Another one to mention too is CISOs recently enacted, well, I should say it's not actually in effect, but CIRCIA, so the Cyber Incident Reporting of Critical, Infrastructure Act. And that's another, I believe it's maybe 4 days, but yeah, right around the 72-hour to 96-hour mark. And so where that leaves organizations and CISOs is in a tricky spot, right? And I think it speaks to the need to really focus and be strategic about preparedness and have tough conversations ahead of time and ahead of any incident with, external counsel and really across departments, if you will, to think through some of these things so that you're putting yourself, your business, in the best position possible for when you inevitably do have something happen.
Right. Now, obviously, from time to time, things do happen, and some cases go high order, at least in terms of publicity and awareness. And one of the things you can do is, I remember reading something, it said, a poster, I think I saw it back in, grammar or junior high school. It's like, a fool never learns from his mistakes. A smart person does learn from their mistakes. A wise person learns from others' mistakes.
Yes.
And so if we want to put on our desire to be wise, what if we take a couple of recent cases, relatively speaking, like SolarWinds or Colonial Pipeline? What lessons can we learn out of that? And what is it that we could look at to go, okay, yeah, I'm going to go look to make sure that doesn't happen here?
Yeah. So for me, the first thing that stands out for some of the more high profile incidents is just how unsophisticated the root cause of those attacks were. Mm-hmm. Let's start with Colonial Pipeline, right? The bad actors leveraged an exposed employee's password to access Colonial's VPN, which in turn got them access to the company's network. This past spring, United Healthcare Group CEO Andrew Whitty mentioned that the root cause of Change Healthcare's attack was a compromised Citrix portal. And so, it's amazing to me that even as far back as like Target, right? And I think it was the HVAC vendor that had been given administrative access.
Privilege.
Fazio
Mechanical, I remember the name, had to think about it a moment.
We're still seeing the same mistakes made over and over again, and for me, it calls to mind, there's a Tony Robbins quote that I often use in presentations with clients when I'm talking about cybersecurity. And it actually, really supports. I watched a video you did within the last few months on complexity and how complexity is killing cybersecurity. And the Tony Robbins quote is that complexity is the enemy of execution. Mm-hmm. And I think that really speaks to, and I've seen it firsthand, the idea that clients, are throwing money at the problem and they're spending half their budget on the most sophisticated tool set. And then lo and behold, they're not even deploying those tools correctly, right? And they aren't focused on what I would consider like the essentials of security, the deploying multi-factor authentication across your environment, routinely reviewing administrative privilege, looking at your password policy and how that's being implemented and used throughout an organization, really focusing time and energy on training employees, right? Because more often than not, and a lot of the ransomwares I've worked over the years, patient zero starts with an employee who, received a phishing email and clicked a malicious link that then starts the download of, a ransomware executable. So for me, it's like, I try to really remind clients, let's think about doing the essential security controls. Let's implement those. And really, I think that'll help eliminate a lot of the risk. And then the second point I want to make about some of these, high profile attacks is how they've informed, subsequent law and policy that have come out of that. So, with SolarWinds and Colonial, that largely informed CIRCIA that I had mentioned earlier, that, CISO was in charge of promulgating. And SolarWinds, I think, absolutely informed the SEC's update and amendments to the cybersecurity rules for publicly traded companies. So I had mentioned this earlier. I think the same ultimately will be and can be said for these healthcare attacks that have happened recently and the soon-to-be updates to the HIPAA security rule.
Mm-hmm.
So all of that to say, for me, the two big things are just, really focusing time and efforts on the security essentials, if you will, and then looking at how those attacks have informed policymaking.
Yeah, and we've talked about a couple risk vectors. One of the risk vectors being that of regulators. One of the risk vectors being that of lawsuits. But realistically, those two are almost subordinate to what I think is a greater risk, which is going to be threat actors. And in particular, if we take a look at where money is, if you remember the idea of Willie Sutton, the bank robber, where he said, why do you rob banks? Because that's where the money is. We find that there's ransomware groups. And these ransomware groups, which operate outside of U.S. jurisdiction, are organized like businesses. They have a CEO, they have a HR department, they work hours, they get a payroll, and this is big business. We're talking billions of dollars, and it's all operating obviously outside of U.S. legal framework, but it is able to impact U.S. organizations. Is there any perspective on what, we can't do a lot, you think? You can't go ahead and just put a warhead on a forehead, and I don't think U.S. government's going to do that. What's happening? Is this just going to be a scourge we live with?
Yeah, you raised a lot of salient points. Ransomware is, at this point, unequivocally an epidemic that's just not going away. And I oftentimes, unfortunately, after the fact, for most of my clients, have to remind them that these groups, they don't discriminate. They could care less about size and annual revenue of a victim organization. Those are not metrics that are informing their decision making of, compromising a network and, acquiring and exfiltrating a terabyte of data from that victimized organization. So it's all about, as you mentioned, just the intent to get paid and do so as quickly as possible so they can move on to the next victim. Mm-hmm. So I think that's just something really important to reinforce, because I've handled ransomware incidents for mom and pop shops that, unfortunately for many, put them out of business, all the way up to Fortune 500 companies. And it never ceases to amaze me that more often than not, a lot of the prevalent thinking is that I just wouldn't have thought that they would have targeted me in the first place. The second point I want to make about these threat actor groups, and it's one that you touched on, is, the challenges that law enforcement faces and really trying to bring these criminals to justice. I don't think most companies understand the work that's going on behind the scenes, or really give law enforcement enough credit in trying to combat what essentially is the 21st, century version of modern warfare. So they're fighting an uphill battle, oftentimes against nation state backed adversaries that, are not capable of being extradited. I oftentimes encourage clients to let us liaise with the different FBI task force that are in charge of pursuing specific ransomware threat actor groups. One from a few years ago that I got to know the individuals of this particular task force really well, unfortunately, because we were routinely having clients that were impacted by them, but it was the Conti ransomware group.
Right.
And so, the men and women that worked within this particular task force group had really valuable intel for us, right? And being able to share, even if it was after the fact, things like IOCs or TTPSs, was helpful. And not just from like the civic standpoint of doing good and trying to prevent someone else from being victimized. I think too, it provided kind of a unique perspective in the sense of, them being able to provide some really good threat intelligence. I will say it didn't happen or has not happened very often, but there have been instances where I've had clients when we've contacted these task force groups, actually be provided a decryptor. And so, I don't think that's something, an expectation that companies should have. Should you be?
But sometimes you get lucky, yeah.
But sometimes you get lucky, and it reinforces the idea that there's a real misperception, if you ask me, around clients having a healthy dose of skepticism that the FBI is going to try to meddle in, the resumption of business operations, and the FBI is going to try to dissuade them from paying a ransomware. That has not been my experience. And I think, the FBI more often than not to speak for them or put words in their mouth, but, they will toe the company line of like, we don't encourage anyone to negotiate with terrorists or pay terrorists, but at the end of the day, it's a business decision, and businesses are going to do, oftentimes whatever necessary to get back to being able to do business. So, I think those are the two things I really want to bring up, when you're talking about ransomware in general.
Got it. Yeah, it reminds me of the flight attendant. There was a flight a couple of days ago. The gentleman next to me, they're getting ready to land. He says, "You go to the restroom." And she says, "Well, I can't tell you yes, but I can't stop you either." And it's like, okay, fine. You're not supposed to do it, but yeah, it's okay. So I get that. Hey, you know what? I'm thinking we're about halfway through the stuff I want to talk about, and we're already almost at the end of an episode. So here's a couple ideas. Number one, how would someone get a hold of you if they said, "Hey, this guy is smart, he's articulate, he knows things that I care about, and I want to just get in touch with him"? How would someone best reach you?
Yeah, absolutely. So, I would encourage them to go to our website, which is the name of our firm, rittergallagher.com. We have a fillable contact form on the site, or they can just reach out to me directly via email, thomas@rittergallagher.com. I oftentimes love to hear from prospective clients that way. And our firm, I think, is really predicated upon wanting to form a long-standing relationship with clients, right? So, anytime we can be of service to people, whether it's just talking about cybersecurity in general or maybe doing more nuanced projects, we always love to help.
Well, got it. Well, I'm going to do is I'm going to probably bring you back for a second show. We good with that? So we can go ahead and finish all the stuff we want to talk about?
I would love that. Yeah.
Awesome. All right. That sounds like a commitment to me. I'm going to hold you to it. Okay. For our audience out there, hey, thank you very much for listening in. We've been talking about cyber legal tips with Thomas Ritter, an attorney who specializes in that area. He's down there in the Tennessee area, and you don't, of course, have to be in Tennessee to be able to work with him. But I think this has been fascinating. I've got a lot more, so we're going to do another episode, but just not today. So this is your host, G. Mark Hardy. I appreciate you tuning in to CISO Tradecraft. Until next time, Stay safe out there.